Hello friends, in the series on the income tax cases, today we will discuss a very important issue which is regarding the mistake done by the assessee in filing the return of income in a wrong form and choosing the wrong section while filing the return of income. The issue before the Honorable Punjab and Haryana High Court in the present case was that if such a mistake happens on the part of the assessee, then what is the right action in case demand is created by CPC and the penalty notices are sent by CPC, whether the assessee should choose to go to the writ court or choose to file the rectification application under section 154. Especially in a case when this return was declared defective, the assessee has not responded to the notices sent by the revenue regarding the defective return of the assessee. This matter has been decided by the court in the case of Cutler Hammer Provident Fund Trust versus Income Tax Officer, and this case is reported in 478 ITR at page number 231, and the date of the judgment is 29th August 2024. In the present case, the assessment year is assessment year 13-14. The assessee filed its return of income, but when the assessee filed the return of income, it mistakenly filed the return form 7, which is for the charitable organizations who are registered under section 12A, and the assessee chose that he has filed the return of income under section 139 subsection 4A while he was not supposed to file his return in ITR 7 under section 139 subsection 4A, meaning thereby that both the form and the section were chosen wrong by the assessee. While the return was processed by the CPC, a demand was created by the CPC due to filing of wrong form by the assessee. Before that, the CPC has given a notice to the assessee for correcting the defects in the return, but the assessee could not reply to the notices for some reasons, and due to which the case of the assessee was transferred from the CPC to the jurisdictional assessing officer. When this matter was before the AO also sent the notices for penalty under section 221 subsection 1. The assessee, in spite of getting this mistake rectified at the AO level by filing the rectification application under section 154, choose to file the writ petition in the court. The court said that this is not a fit case for the court to be heard because in the present case the assessee plea that he was not having the knowledge of filing the wrong form was not correct, because in the present case for the assessment year 14-15, that is the next year, the assessee himself has filed the revised return for correcting the same mistake. So there was no occasion that the assessee has not corrected the mistake for the assessment year 13-14 by filing the revised return, and even if the time for filing the revised return was lapsed, the assessee can go for section 154 rectification application. The court dismissed the writ petition of the assessee but gave a rider that if the assessee choose to file the rectification application under section 154, then this mistake can be rectified by filing the rectification under section 154, and said that the revenue can dispose of the rectification application under section 154 as per law. Friends, what is the takeaway from this case? The takeaway from this case is that some people took the compliance part, like filing of the return of income, in a very casual manner. So first of all, this casual approach should not be avoided, and at the same time, just to avoid that situation that you miss some notices issued by the CPC or the revenue, it is the foremost duty of every assessee and the professional who is handling that assessee that they should update the email ID and the mobile number of both the assessee and the professional at the income tax portal, because sometimes it happens that the file moves from one professional to other professional, and it is seen that in such a situation the returns are being filed without updating the contact details of the present professional or the assessee. So if the correct details will be there, correct contact details will be there, then there will be very less chances of missing any notice, because if in this case the assessee has just attended the notice, then the assessee should not have to travel to the writ court and then filing the rectification application under section 154. So in the nutshell, if the assessee had made a mistake in filing the return in wrong form or in a wrong section, that can be rectified by filing a rectification application under section 154. Thank you, friends.